right, we're here on case number D 402438, Stroh versus Lavin. Counsel, please state your names and bar numbers for the record.
Thank you, Your Honor. Patricia Vaccarino, bar number 5157, present and appearing with the plaintiff, Anthony Stroh.
Good morning, Your Honor. Shay Backus, bar number 8361, appearing here today with defendant Athea Lavin.
Anybody got an update for me?
Yes, we both do.
I can kind of provide it. What we're going to ask the court is the parties are in a situation where they have a drafted partial parenting agreement, and so we've agreed to have them go back to mediation in an effort to finalize this and also try to finalize, maybe hopefully resolve. Well, no, they were close. I mean, there's just some little things that needed to be tweaked in, and also maybe some other issues to be resolved. But also, I think we would request also just an evidentiary hearing to be set, so we have some kind of.
I consider those two concepts logically inconsistent.
I
don't want to give somebody an excuse to say, "Oh, we'll have our evidentiary hearing. We don't really need to talk." I don't do that.
Okay. I sometimes deadlines work better for attorneys, maybe.
Your settings come pretty are going to fall pretty fast, Your Honor, correct?
Reasonably so, yeah.
And we're saying, if you can give us a return date like 30 days, I wanted to just itemize in the record, Your Honor. If you want to keep people like true to what they've agreed to, we can itemize.
Let me get to that. Okay. I think we're still setting in May, aren't we? Full day. Full day's June, half day's May. That's not that far.
We come back in like 3 weeks a month, because there's, like you said, there's only some tweaking to be done, and some of it we've even agreed to in the hall. Like, for instance, the vacation says 14 days notice. We've agreed it'll be 21 days advance written notice. They're going to get rid of Monday holidays totally because they have a 3-2-2-3. Or if that's your weekend and it falls on your weekend, they make the exchange time later than 3 if someone's going out of town.
And there's just some
transportation language,
there's just some language,
daycare language they're going to work on. And I think that was the only substantive, really, changes that were going to be made to the partial plan. The big one is, the reason why it's partial is because they couldn't agree on the final physical weekly custody designation, and Mom agrees to go back, and Dad, for the time being, if they could negotiate, would be willing to keep the 3-2-2-3. Mom and Dad have been doing that. They're going to do it pending the continuance. There's not been any nasty letters or allegations going back and forth. It's all good news. So the hope is that they're going to agree to confirm a final order, and then if not, we'll get on your trial, docket right away. So it's not, my client was concerned, we want to ratify this, we want a trial date, but I think because they're so close that it does make sense to let them go back in for a half hour on those few issues that the mediator will have.
How has the 3-2-2-3 been working out?
Doing well.
Are you asking me?
Let me ask the question differently, because I know what answer I'm going to get on this side. How has the 3-2-2-3 been working for Caden? Ms. Shea, you'll tell me what your client's response is. I don't want to hear from her.
You don't want to hear from her, or do you?
You're her filter.
Okay, I'll be the filter. I think Mom has had just a couple concerns with Caden, and it's the same issues we brought before Your Honor originally with the eczema and some other issues. And there's been some allegations of stalking that Dad has been peeping into her windows on the days. I mean, there's some concerns that way. And those were the days she had Caden. There's just been a lot of communication things, and this is why I think sometimes the FMC can kind of help them hopefully resolve some issues with communication and behavior.
I have a great idea. Why don't you both make an appointment with a dermatologist? Bring Caden in together and have the dermatologist tell you what course of treatment Caden needs. Because eczema is a common problem in America. I don't know whether it has to do with our food supply or what, but an awful lot of kids seem to get it that I don't remember years past. And so maybe there is a course of treatment that the doctor can tell you both. You can both agree on doing it, and that's one of the issues. As far as stalking, if there's really evidence of stalking, maybe she wants to set up a motion camera system, so if he shows up, she got him on camera peeking into her door or her window, and try to move forward. Right. Beyond those two issues, is there anything else that's causing harm to Caden? Not to either party, but to Caden.
In the sense of the word harm, I think we haven't had really any incidences like car accidents or anything like that. The concerns are the same ones we raised before the court. Was like, he was just sleeping too much, just getting adjusted when he comes home, things like that. Thea's kind of
That's
under
gonna
the
be the rest
understanding
of
there's
their
two,
lives.
right? And this could be just his age right now. He feels closer to mommy. Things like that are just getting resolved.
And guess what? I want you two to remember one thing. Your child is 2.5. You know what they do at 2.5? They do whatever they can to make their parents feel guilty and bad and scared, because it gives them security when you become angry and scared. So don't necessarily assume that the child's come to some harm in the other home just because the child's acting out. That's what they do. And Caden's had to get used to having, 2 homes that he lives in on a regular basis. But if you think he's going to stop making the two of you feel guilty, oh gosh, you're kidding yourselves. I think any parent in the room can tell you that's the age when they do it. And when he's probably with Dad, he's probably clinging to Dad, making it as though he just doesn't want Dad to be going away. They do it. Probably experienced it if you've taken him to daycare. That's what they do. So you can't assume things. That's the thing you have to start doing, is trusting each other. And if there's a problem, if Caden's doing something, you call the other person. But as far as the eczema, it's very uncomfortable. It could become infected if he scratches at it too much. I think you both should together go to a dermatologist and find out what is the problem and what you need to do.
Yeah, the child went to, Dad actually brought him to the pediatrician, and hydrocortisone, right? Which my daughter had slight eczema too. If it gets worse, there's another steroid cream they can prescribe, but I think it's a great idea that they could both go talk to the pediatrician and see if possibly an allergist and or dermatologist. I've seen this in a lot of cases with kids under 5. They grow out of it a lot of times too, and as my kids did. So one other thing that you brought up, daycare, he is in daycare, and they've been going back and forth on that issue. They've agreed to keep the child in that daycare pending final mediation and or further order of this court, which will be hopefully soon down the road.
I just want to clarify that, because one of our concerns was this, and this is what they were going to discuss during mediation, Your Honor, and I hate to bog the court with, like, little things that they can hopefully resolve. But one of the big things was just financial concern that if, like, power bills start going up, as you understand, these two now have 2 separate households, and just bearing all the bills, is there may become a time that mom can no longer afford keeping him in the daycare and may have like a parent who could watch. And so those are kind of just issues that still just were outstanding that they were going to discuss. If
they're
it comes to a
splitting the
point.
cost of daycare and your client's income hasn't changed, she can afford half of it.
Well, before she was paying all the house bills but not paying daycare. And so now she's paying half of daycare, along with Dad paying half of daycare. The concern would be, Your Honor, if like bills go out of, if she couldn't afford her mortgage one month and daycare.
And my client understands that. That's what joint legal custody language is there for. And like a school or a daycare, they stay enrolled present. They consult and cooperate on a change. If they can't reach an accord,
And
then
I once again remind the parties that I'm the last person you come see.
please.
You know, there's nothing wrong with cutting each other a little slack, trading horses, all those things I talk about. If you have a month, for example, that you had an unexpected expense, you call the child's father. Can you front me for this month? And you come up with ways to compromise. Maybe they're money, maybe they're not money. But that's why you talk to each other, not me.
Right, and we understand that. That's why we just didn't want an order that was so black and white that kind of forced the issue.
I issue an order. I order people to do things. That doesn't mean that they can't do something else if they agree otherwise.
That's exactly the kind of language I asked for when we were negotiating. That's why the order's not entered yet, the joint legal custody language, that they want this neutral exchange place and they can change it. And I said, let's have a specific place with a provision that says if that doesn't work, that they text each other or write each other and they mutually agree on another, because my experience in this case is that fallback kind of specificity with you still guys get to grow up and get along better down the future is perfect for this case.
Here's the thing. They no longer reside together. They are going to be moving on in their separate lives. Caden will more likely than not have one or more stepmothers. He may have one or more stepfathers. He's going to graduate from preschool. Then he's going to graduate from kindergarten. Then he's going to graduate from grade school. And then he's going to graduate from middle school. Then he's going to graduate from high school. Then he may graduate from college. Wouldn't that be lovely? and he's going to probably get married. You got lots of time to spend with each other. Lots of time. And if you think it ends when he's 18, don't kid yourselves. Now's the time to put whatever you feel about each other aside. Because you never want your son's wedding to be spoiled because his parents despise each other, do you? Or his graduations, or any little function that he has. I mean, maybe he'll take up karate, and he's got they have a show. Well, wouldn't it be nice if you could both go, smile at each other, maybe even sitting with your new significant others, and all he sees is harmony, and he gets his childhood. That's what you got to do. And that means that I can issue orders. And if you two disagree with me and you agree with each other, you can do something else. You don't need me. Again, remember, last person you come to see. So I issue these orders, and then you talk to each other. Like I said, if your client has a bump in the road, she doesn't come to me. She goes to the father first. Says, can you front me? I'm having a tough time. Vice versa. If for some reason, is your client still a painter?
Yes. Union
Still
painter.
gainfully
Yes.
employed?
Union painter, yes. Luckily so.
But, the vagaries of union labor being what it is, he may call you one day and say, look, I need a little help if you can do it. And let me see, what can we work out that gives you a benefit? Yeah, like I said, horses in your barn, you trade them. You don't need me for that. That's the whole point. The more you're coming to me, the more you've forgotten that. So I'm not making any changes. I'll maintain the status quo, and the two of you can go back to mediation, try harder, come up with an agreement, and never have to see me again.
Hoping for that.
And counsel, have you worked out the child support issue?
That's what we were going to say. The last order, if we can include a clerk's a minute that corrects the last minutes. There was one error in the minutes where it stated the parties were going to equally, that Dad was going to pay daycare. But I went back and looked at it, and Ms. Backus agreed that, and the way I
said 50-50.
It is 50-50.
And we were just going to wait till the year end to calculate child support because they both had two different sources of income, and we just wanted to
You
wait
should
for the
W-2s and calculate.
It's still pending, and we've already negotiated. When we come back, we'll have an agreement.
Go around at mediation, you're going to give me those numbers.
Yes, Your Honor. And if we can't decide, you will. It's not that.
We agreed on how
You're
it's
going
calculated.
to give me the map, but you don't need me as your bookkeeper.
No, even though you're better at it than me for sure. The numbers.
So then all of a sudden, Ms. Backus has a flair for math.
I do, actually. I was an auditor before I
both
went to law
of you.
school.
There you go.
It's not bad.
All right.
So I think that covers everything. On the daycare, because you said they're going to maintain the same daycare absent a new agreement, because you said you're going to maintain that status quo, correct, Your Honor?
Mm-hmm.
Okay. I'll prepare the order and send it to Ms. Backus for her.
All right.
The other order, we have a few language issues, and it's done this close. I think by next week we should be submitting it for you, Your Honor.
Please do.
We're working on it, believe me. We went back and
All
forth
right.
in some JLC language.
You're coming back in April on this, and hopefully that's the last time you two have to come see me.
What's the date?
Oh, yeah, what's the date, Your Honor?
April 7th at 11 a.m.
Thank you, Your Honor. Good day.
Thank you.
Oh, who's preparing them today?
I will, Your Honor.
Yeah, I think the judge wants us back.